Number 97, the people of the state of New York versus Peter Austin.
Good afternoon. My name is Mark Zeno, and I represent appellant Peter Austin. I'd like to reserve 2 minutes of rebuttal.
You may, Mr. Zeno.
Thank you. I plan to argue both points today, but I'd like to begin with the Confrontation Clause point. In People v. John, this court held...
I'm sorry, Counsel, before you get to that, could you talk a little bit about how this argument is preserved?
How it's preserved, sure. When it became clear that criminalist O'Connor was going to be testifying, defense counsel objected to the admission of DNA testimony without calling the appropriate witnesses. And then there followed a colloquy about which witnesses were necessary to be called. Defense counsel cited Melendez, cited Williams v. Illinois, referred to the fact that O'Connor was only the supervisor on two of the three tests, and essentially said that he was the wrong witness to be calling, or an inadequate witness to be calling under the Confrontation Clause.
So, Counsel, you're referring to the portions at 936, maybe through 939 of the record, I think. And let me ask you this. The way this starts out with the court, for the first couple pages, the court is identifying 3 laboratory reports. These are documents. And at least, one reading of this is that Mr. Sandleitner's objections were to the introduction of the reports. And when he cites Bullcombing and Melendez and so on, those are cases about the admissibility of reports. And then what happens after that is the court ultimately doesn't, am I correct that none of these reports were actually admitted into evidence?
That's correct.
And then what happens after that in the trial is that Mr. O'Connor is qualified as an expert without objection from Mr. Sandleitner, and then testifies as an expert. And sometimes Mr. Sandleitner makes objections, and sometimes those are sustained, and sometimes they're overruled. But if there's something that you can point me to in addition or different from what's at the pages I just mentioned, where there's an objection on Confrontation Clause grounds to O'Connor's expert testimony, I'd like to see that.
Well, you're looking at the correct pages, Your Honor, but I read those objections differently.
Okay.
I think that when the objection, counsel stated he was objecting on Melendez-Diaz grounds, and he said that the prosecutor was attempting to elicit testimony from witnesses who would not be called, and was trying to get around that problem by calling a criminalist to testify as a supervisor. And perhaps defense counsel could have been more precise, but when he was objecting to this witness testifying as a supervisor, I mean, that was certainly an adequate objection to put the court on notice that he was an inadequate witness, particularly because this case was tried before People v. John was decided, where these precise rules were laid out. He was objecting to the criminalist testifying as a supervisor.
For the purpose of admitting the reports, or for any purpose at all?
For the purpose of admitting the evidence, whether it came in by virtue of the report or came in by virtue of his live testimony. He was objecting to the admission of the evidence. It's the evidence, whether it came in through a report or whether it came in through a live witness. He was saying that you needed someone who was qualified to testify, and a supervisor was inadequately qualified.
And it seems...
I thought the objection related to the calibration of the machine.
Well, counsel took a very broad position. Again, this was a pre-John case before this court laid down some very specific rules about which witnesses were required to testify. Counsel was saying you needed to bring in all the witnesses. that the all witnesses rule, which is referred to in John and rejected, you needed to bring in all these witnesses. Every stage of the testing, you needed to have a witness testify. And before this court decided John, it was unclear whether that was necessary or not. But the fact that he asked that they bring in all the witnesses didn't waive an objection to at least bringing in one necessary witness, the one necessary witness who either was the person that called the alleles, as this court talked about in John, or performed an independent review of the data.
Well, so looking at the 3 reports, can it not be said that Mr. O'Connor performed the same review of the raw data that for the buccal swab that he did for the crime scene DNA? And can't we infer that from the fact that he initialed all of those pages? And on those pages, he's listed as the analyst.
He did initial all the pages. There was no testimony as to what his initials meant. We do have his testimony about exactly what he performed with regard to the post-arrest swab, and that's at page 1004 and 1005 of the record. And when he is being examined by the prosecutor during direct examination, the prosecutor asks him, "Did you analyze the DNA profile in this particular case?" Answer, "I reviewed the DNA profile in this case." Question, "And when you reviewed it, what did you do with it?" Answer, "I looked at the DNA profile, the string of numbers, which is the DNA profile, and compared it to the other 2 reports." He compared the string of numbers, and that's the box score that the court talked about in John. He compared the numbers that had been prepared by others.
And it seems a hard argument to make that you can get around what we say is a confrontation clause violation in John by just not admitting the report, and what he seems to do in his testimony to me is rely on it and refer to it throughout his testimony, because it seems the harm in John wasn't the report, it was the potential for tampering or contamination that might be there if you didn't call someone who was actually involved in a critical stage of the DNA analysis.
Right, and I think that John anticipated that. If John talked about Williams v. Illinois, where exactly that happened. In Williams v. Illinois, they didn't admit the reports as here, and they called a witness who basically testified to conclusions based on those reports. And in Williams v. Illinois, the dissent specifically pointed out New York law, People versus Goldstein, and said, what you're doing here is unlawful. Courts in states like New York don't allow it. And then when this court decided John, it reaffirmed that rule, that it doesn't matter how that data comes in, it doesn't matter how those conclusions come in, whether it's through a report or whether it's through a live witness, it's the evidence that's the problem. It's the potential for tainted evidence, tainted conclusions in that evidence.
So, counsel, let's say we agree with you. Do we have to reach the adverse inference issue?
Not if you agree on this point, but I see my time is running out, but so let me turn to that adverse inference point. In People versus Handy, this court ruled that regardless of whether evidence is technically discoverable, if it has been requested by the defense with reasonable diligence, the prosecutor must take whatever steps are necessary to ensure that that evidence will be available to the defense. Here,
Now, even the dissent in applying Handy seems to require that the defense act with some reasonable diligence in making the demand. What's your basis for saying that the defense got it, the majority got it wrong in saying that there was reasonable diligence by the defense?
well, the defense made a demand in December of 2010 for all of the evidence, which would have included this bloody receipt.
And then how long did it go by unresponded to before the defense woke up?
In June of
and said,
2011,
I
there
need
was
this?
a status conference where the court directed completion of discovery, and when the case moved for trial the following year, 16 months later, before jury selection started, the defense specifically again asked for all the evidence from which the DNA was derived, and the court said to the prosecutor, deal with it. 5 days later, it still hadn't been dealt with. when Hurricane Sandy made landfall and the evidence was destroyed, that was still an outstanding request. So in the middle of jury selection, after the court had directed the
See,
prosecutor
that's why
to
I'm
turn
wondering,
over.
why would Handy apply since the destruction of the evidence wasn't lost by an agent of the
Right,
state or
so
destroyed?
Handy-
Follow up on that. What would the adverse inference be that would be drawn?
Well,
What's the adverse
The
inference?
adverse inference is that that the jury was permitted to draw the inference that the evidence would not have been favorable to the prosecution. That,
That the scientific testing that was performed?
well, no, ultimately the scientific testing. If this bloody receipt had been contaminated or there was proof of contamination in the way it had been stored, that might have affected the ultimate
But
testing.
isn't that
of it.
argument that they'd have to be deciding that because the people dragged their feet, the evidence was adverse to them? And that's not what these cases turn on, right? It's the failure to actually turn over the evidence, or that it's destroyed and now you can't turn it over.
Right.
That's-
Lost or
As
destroyed.
opposed to, they dragged their feet, and maybe that day they would have turned it over, but now Sandy hit, and it's impossible to access the material, even if it still exists.
Well, that's right. Well, this case is distinguishable from Sandy because it was not an affirmative act of destruction of the evidence. But it was destroyed.
That's the question
because
for
of
us,
the-
is this an act of God? Seems like we're going to have more hurricanes. This may be more of a question that we may have to deal with more often, all of us.
Well-
So that being the case, or is it an act of the state?
Well, it's.
Or as a follow-up on that, do you get this adverse inference if the people have only dragged their feet 2 months?
Well, that's not this case, and dragging, that would be a question for the court. Here, we have a period of multiple years where the people drag their feet. And getting back to your, sort of the original question is, we'd be asking for the jury to be permitted to infer from the fact that they delayed this disclosure for 2 years, or delayed producing the evidence for 2 years, that from that fact, the jury would be permitted to infer, but not required to infer, that the evidence wasn't favorable.
Was
Thank
this-
you, sir.
Oh, I'm sorry. Never mind.
Counsel?
May it please the court, Matthew Benjamin White for the District Attorney of Bronx County, Darcel D. Clark. Your Honors, to take up with the adverse inference point, defense did not exercise reasonable diligence in asking for the property.
Let's assume for the moment that they did. I think probably everyone agrees that it wasn't their fault that the hurricane contaminated where this was stored, and that there was nothing improper about where it was stored or how it was stored or anything like that. The issue to me boils down to they did delay for a very extensive period of time, and as a result of which the evidence is no longer there. So somebody has to bear, the brunt of that, if you will. Either the defendant is harmed by the fact that this happened, and allows the jury, the inference allows the jury to decide that, yes, it wasn't their fault, the hurricane wasn't their fault, but had they complied with their obligations, this never would have happened, and, maybe there's a reason they didn't comply with their obligations, versus if there is no permissive inference instruction, then, then this unanticipated loss, it falls on the shoulders of the defense, and the prosecution is sort of scot-free on having failed to comply with their discovery obligations. That was a little long-winded, but I think you get what I'm saying.
Yes, Your Honor, but with respect, I take issue with the premise that there was an undue delay on the part of the people.
Well, obviously, I think that would have to be
And
the
there's no
premise.
evidence in the record to support that.
But
Notably.
what if there
the bill-
was? What if there was?
What if there was?
Yes, what if there was? So, then you've got this balance, so what,
Well, Again,
why
I
wouldn't a
take
permissive
issue with the premise, but assuming there was, then because it was a once-in-a-lifetime meteorological phenomenon, I think in this case, that an adverse inference would not be required.
Well, what if it wasn't a hurricane? What if it was a robbery?
If someone broke
burglary.
into the police warehouse and
Yep.
stole the property?
Yep.
Well, in that case,
Or what if it was a
arguably-
fire, or, any number of things, a flood?
well, Your Honor, I mean, it's sort of a hypothetical far removed from this situation. I mean, we are talking about an act of God. We are talking about a once-in-a-lifetime event.
No, I understand, but just assume that something happens that is not the people's fault, that the event that results in the loss of the evidence is not the people's fault. I think that's the point.
Well,
But had they been timely in their disclosure, the stuff wouldn't have been there. It would have been in the hands of the defense.
Your Honor, if we did delay, and
I understand,
we did not, and if, say, a robber broke into the warehouse and stole the property, and if somehow this robber was, some kind of super robber, that, the police were somehow negligent or not negligent in stopping him, arguably, an adverse inference in that unique situation might be warranted. But we need not go that far. This is a case where, notably, the bill and demand is not in the record. So Your Honors have actually no idea what property was requested. And I would submit to Your Honors that the property at issue here was not discoverable under CPL Section 240.20. Under that section, the only property that is
But I
discoverable,
thought the judge ordered you to turn it over.
the judge ordered us to
So
comply.
I don't know that that's your strongest argument, right?
Well, Your Honor, the judge ordered us to comply with our discovery obligations. This was not property that was discoverable as of right.
But he set out what he wanted, and that's what the judge ordered, right?
Well, there are two.
Not say, I want all the DNA,
But if you're not
evidence?
entitled to it, Your Honor, then why would we?
but if the judge ordered it,
But if.
Isn't
if
that
the
where we
ju-
are here?
The judge did not, no judge ever specifically ordered
Hmm.
that this property be turned over. No judge ever ordered that, Your Honor.
Mm-hmm. so
They
what did the
ordered us
judge
to-
order be turned over then?
I'm sorry.
I'm sorry, what did, in your opinion, the judge order to be
The judge
turned
ordered us to
over?
turn over the discovery that the defense was entitled to.
Never mentioned anything specific about DNA, either in response to a request or some statement from the prosecutor related to the DNA evidence?
Your Honor, the only evidence in the record related to this
Mm-hmm.
appears at page A54. It's the first day of trial, when defense counsel says, Your Honors, I haven't seen the physical evidence yet, but the prosecutor's been very accommodating. I'm sure we'll make arrangements. 5 days later, Sandy strikes. Under those circumstances, where defense counsel has waited 2 years to look at this property.
Was there ever any discussion about making arrangements to have the evidence tested?
No. In fact, defense counsel specifically stated he did not want to test this evidence.
So
And
your
so-
position, bottom line, is that they didn't exercise reasonable diligence?
Yes, Your Honor.
Now, I want to go back to the Confrontation Clause, which you haven't addressed, and give you a chance to do that.
Yes, Your Honor.
Because I think you would agree, we don't need to reach the adverse inference issue if this case is resolved on John in favor of the defendant.
Correct, but the issue is not preserved, Your Honor. The objection that defense counsel is pointing out to occurred on the last day of a month-long trial. The last day, right before the witness was about to testify, not for the first time, but for the second time, right? So clearly, the objection is not timely. And also, I submit to Your Honor that the objection is not made with any kind of precision. You're dealing here with a very complicated area of jurisprudence, 3 different DNA reports where up to 6 analysts might be required for each report. So we're talking about 18 potential witnesses.
But is the objection made before the testimony he objects to is given? So what does it matter if it's the last day or the first day? I mean, he objects before the testimony is made.
He does, well, as I said, the witness testified previously.
But
and he
to
laid
The
out-
judge could always strike it if it turns out it was wrongly allowed.
Right, but
And
this,
then there's there additional testimony after he makes the objection on this issue?
yes, but the objections are misplaced because the objections are related to the crime scene reports. They're not related, and those, counsel concedes, are not testimonial on appeal, right? Counsel's issue on appeal is that we should have called the analyst for the DNA buccal swab that was taken from the defendant later. Defense counsel never asked for that witness to be called, okay? He said that we had to produce the witnesses who calibrated the machines, And the court said, no, the people are not required to produce all witnesses, which is exactly what this court said in Sean John. The people are not required to produce all witnesses related to a DNA report. And so there's no precision in the objection. We had the court was not alerted to the particular error at issue. And that's why no court has ever ruled on this issue in this case. Not the trial court, not the First Department, and I submit that Your Honor should not be the first to rule on this issue in this very complicated area of jurisprudence.
Is there anything in the record that shows Mr. O'Connor performed more analysis of the raw data of the buccal or buccal, as you're pronouncing it, so I don't know which is correct, swab than the analyst in John?
Yes, Your Honor. I mean, at page A984 of the record, Mr. O'Connor talks about the standard testing that he does when he writes up a DNA report. And he states that after all the testing is done and all of the data is compiled in the case file, in the case folder, everything is put. I reviewed every test that was done, every control that was involved, and all of the data that was finally found, and I made a determination of a DNA profile. So clearly, he's taking responsibility for the DNA profile. And the DNA profile at issue in this case was essentially machine-generated. If you look at the DNA report that counsel takes issue with on appeal, you can see that, and this is at A1263, the electrospherogram essentially sets forth the alleles as they appear on the allele table at A1260, right? And it's an exact match. And then when you look at the edit table on A1262, they refer to 4 samples that were edited in that batch of 25 that was tested, but it's not our sample. So this is a situation where the alleles are essentially machine-generated. And
Isn't that the case? That was the case in Sean John. I mean, that fight's been lost.
Your Honor, I disagree because
All of them
I
are
believe...
generated by a machine, and the point is, it's who's doing that.
No, Your Honor, with due respect, the gun swab in Sean John was edited. It was
It was
edited.
edited for certain peaks.
For peaks. I'm just saying, to the extent, and this is why the preservation issue is so important, Your Honors, because there's no guidance for the court, there's no record for the
Peaks
court.
and editing that was done in there only served to reinforce the point of the majority in that case, which was there's a potential for things to be manipulated in some way at this stage, and that's why you need the person who actually performed it rather than a machine printout that an expert then can compare to a different machine printout.
Your Honor, this is an argument we don't need to have because it's not preserved.
Okay, what should counsel have said to preserve this argument? What's missing from
missing is he should
that
have said-
colloquy?
I'm sorry to interrupt.
Yeah, no.
You should have said, Your Honor, the DNA buccal swab profile is testimonial, and we need to hear from the analyst who did the typing.
If it said it's in violation of Supreme Court cases on this and cited the cases, would that have been enough?
It would not have been enough, Your Honor, because as I said, there are 3 DNA reports, 6 analysts per report, 18 witnesses. We need to know, with some specificity, who to call. Because theoretically, the objections could have been sustained, his witnesses could have been called, and then he could have turned around and said on appeal.
Did the judge's decision perhaps resolve the issue for purposes of this preservation question?
No, Your Honor, because the judge's ruling was that not all witnesses need to be called. That's a very different proposition, that the people don't need to call anyone else. And again, this objection was made on the last day of testimony, on a month-long trial, where defense counsel had the reports for over 3 weeks.
Thank you, counsel.
Thank you, Your Honors.
Mr. Zeno?
What do you say about the objection being on the last day of testimony?
Well, the objection was before the evidence came in. I don't know of any rule of evidence that requires you to make an objection at any earlier point. The objection occurred before the criminalist testified about his conclusions about the DNA. I mean, I don't even actually understand. There's no timing requirement as long as it's before the testimony comes in, and it was before the testimony came in. It was when he learned that this criminalist was going to testify about this evidence, and he objected. And I want to get back to preservation, but I wanted to correct something that respondent said in response to Judge Feinman's question asking about, is there any evidence in the record as to what type of supervision or analysis he performed on this report? And counsel cited to page 984 of the appendix, and where O'Connor said that he had reviewed every test that was done, every control, all of that information, but he was specifically referring to one of the other reports that we don't object to. If you look at 984, question, what role did you play in the analysis of this particular piece of evidence under FB 0904107? And that's one of the reports we're not objecting to.
And wasn't there also a comment on Mr. O'Connor's role that the court made at A1047, saying Mr. O'Connor was ill-prepared. Apparently, all he did was to review what other people did.
Absolutely. I mean, and he testified to that with regard to this report. All he did is review. All he did is create that box score, which under John is inadequate. John made a very precise rule, and he doesn't fit within
To be
that
clear,
rule.
what is it you are now raising as your Confrontation Clause claim? What is it you're objecting to now?
That the evidence from the buccal swab
Okay.
that my client's DNA matched the DNA that was found on the bloody receipt at the bed and bath
It's the
store.
testimony comparing,
It's the testimony
Comparison
comparing.
testimony?
But it's more than that, because it necessarily brings in the testimony of the criminalists who did not testify, who produced the data that O'Connor used to reach that conclusion. He was relying on data of other criminalists who performed the tests, edited the graphs, came up with the numbers, and he just took that underlying number, put it in a box score, and concluded they're the same. So to the extent that he was allowed to testify that they're the same, we object to that, and to the extent that he was allowed to integrate that other testimony that was not admissible, that did not have a constitutional foundation, we object to that as
so
well.
not just the defendant's DNA profile?
No,
Saying
just
the
the
DNA from the crime scene also?
No, we do not object to that, because under John, that is not testimonial, because it was pre-accusatory.
Okay.
Thank you, counsel.
Thank you.